You can see how immigration has completely changed with this case. Many people say you fly to the US, you get married to a US citizen, and you get a green card. Easy peasy. With this case, you could clearly see it is a US citizen marriage. They flew in. Their one little answer that arguably was incorrect with the CBP officer was recorded, and USCIS now issues a notice of intent to deny their green card application. Never mind the marriage is real, never mind it's a US citizen, never mind all that. There is a fraud conviction now on this lady because of one small thing, whether she said it or not, but CBP officer typed it into the system. Let me go through this case with you and what the USCIS officer now required the family to do. The clients flew in 2024. Subsequently, they got married, filed a 485 application. So this is exactly what happened, right? This is the notice of intent to deny. And by the way, if the 45 is denied, the client needs to leave. They cannot do anything else. And if they don't leave, they get picked up by ICE and they put in deportation proceedings. In 2023, they were married. They got a K visa. There's an I-130 that was filed. And the whole reason why there was a fraud claim was because when they were flying in, the lady showed a return ticket. And obviously, the client did not use the return ticket. And then they filed for the I-130 and the 45. And to the USCIS officer, by you showing a return ticket to a customs officer, that was a material misrepresentation. You had the intent to use this return ticket to deceive an immigration officer, showing that you are planning on returning when you in fact did not have that intent. And so when you entered, so you used that, you misrepresented yourself and your situation. So now you have a fraud claim. And that is an inadmissibility deportable offense. Doesn't matter if you are married to a US citizen. A US citizen can help you waive potential unlawful presence, assuming you entered legally, but a US citizen cannot automatically waive any misrepresentation. So now USCIS officers, when they're doing these interviews, they look at how you got the tourist visa, they look through the DS-160 application, they're supposed to check the CBP records, what did you say, and look through anything. And if they find one thing, and in this instance, it was, I have a return ticket. Because you showed you have a return ticket, we deem you to have misrepresented by the actions that you took later on. And so therefore, you need to submit a waiver. What is a waiver? You need to present that without you, the US citizen will suffer extreme hardship in the United States. And if you prove that, then the officer waives your wrongdoing, waives the misrepresentation, and allows you to get a green card. Essentially saying, by removing you, we are harming our own citizens, so we're not going to do that. But you have to prove extreme hardship that warrants a forgiveness of this misrepresentation. It is tough, it is hard, and time is short. A lot of times, 601 waiver applications, we take half a year, we take a year to prepare. But in this case, we had only 1 month. Is it a severe misrepresentation? Is it even a misrepresentation, right? I mean, that's the first thing I always ask. What are the elements of misrepresentation? You showed a return ticket. Does that automatically mean you are deceiving an officer? People change their minds. It's okay to change your mind. It's perfectly legal. I've flown somewhere before and suddenly I don't want to come back so fast. I want to extend my stay a little bit. That happens all the time. Is that a misrepresentation? To the officer, it was sufficient cause to make this claim. Let me go through the waiver application. We talked about the law. We talked about the extreme medical hardship on the U.S. citizen spouse. We talked about the extreme emotional hardship on the U.S. citizen spouse. We talked about the extreme financial and career hardship on the U.S. citizen spouse. We talked about the valuable asset to the U.S. and the good moral character and the final determination. We submitted 19 pages in attorney brief. We submitted over 29 documents, over 500 pages to document why this person deserves to be in the United States and why they deserve this waiver. Normally, again, we have a long time to do it. In this case, it's very short. U.S. citizen, their entire family was freaking out, obviously, because they thought it was simple, right? It's supposed to be, you got a tourist visa, you fly to the U.S., you get married to a U.S. citizen, you get a green card. It should be simple. But one little thing caused the officer to scrutinize it. And if not done well and not done timely, the entire case will be done, and now she will be deportable. And guess what? If she does get deported, probably end up divorce, or it's a long distance marriage for potentially 5 years or longer. It was a very difficult case. I did not think it would necessarily get approved. We did not have super high confidence. We just did our best to make all the arguments that we know, because we do a lot of 601, but we just had to borrow all the tools and make a quick argument here now. We borrow from the non-immigrant visa argumentation, where we do a weighted balance. What was the offense that was committed that was so wrong that the United States government wants to punish this U.S. citizen? They presented an airline ticket. Was it really fraud? We explained that. And all the positive effects of this lady in this marriage with this U.S. citizen in the United States. So just this week, the case was approved. The green card is in the mail. Happy to share that story with all of you. In the past, we would almost never see something like this happen. Officers typically don't challenge these and don't require waiver applications. I don't know if we did an overkill by submitting like 19 pages and 20. Could we have submitted a 4-page attorney brief? Could we have just submitted a checklist of documents and get approved? Maybe, maybe not. We don't know what the officer's mind was, right? But we knew we have 1 month, and we knew that if we don't do it well, the consequences are high. And so we just had to prepare as much as possible, like it's a normal waiver case. And now your case needs to be completely above board, squeaky clean. And if you run into any problem, sometimes you might only have a month to prepare to respond. That's just the law of the land right now. So my encouragement to everyone is, whatever case you're filing, understand it in and out, completely have a mastery over it. With ChatGPT, with AI, you should be able to understand it better than anybody who have ever done it in your life, because it is your one chance, one opportunity to get your visa and get your green card and get your citizenship.